Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
Hello, couch potatoes. Surprise stream today. I just finished up Llama Learns About with my Llama Nerds for our members. It was, boy, what a morning. We learned about some really crazy things today. But this morning, when I woke up, I saw that Karen Reed has officially filed her civil complaint against some of the MSP and the McAlberts. And I was like, oh boy, we're going to have to talk about this today. Now, I have not read it, so we'll be reading it together for the first time. There's also a statement put out by Karen Reed's lawyers. And then there's an article about how the McAlberts and Brian Higgins plans on suing her back. I saw that last night. So very interesting that this was dropped. They said that last night and it was dropped today. So I am very excited about it. Now, I have just been reading for the last 2 hours, so just to let you know, my voice may be a little, but either way, we're here. Hello, Amos. Oh, good. The portal worked for you guys over to this. Love that. Hello, Christy. Hello. Good afternoon. Hope you're doing well. Hi, Pilola's mom. Hello, Angie. Angie's here. She got me the docs for today. Oh boy, I can't wait. Hi, Annie. Look at you popping around during nap time. I love that. Buffy. Hey, Buff. How you doing? And oh, Terry's joined us from bed. Hope you're feeling better, babes. Hopefully. And welcome back, Mama Llama and Sam over on Facebook. Hi, babes. All right. Are we doing a dual stream here? I don't know if we are doing, if so, it doesn't look different. I don't know. I don't know if we're trying that out or not, where we're doing like a short and a landscape. I don't know. I'm just here. I just showed up. So we'll learn together. But yes, so I'm very, oh boy, things are getting spicy. So let's get into it. Before I do though, make sure you guys hit the like button right now because it lets people know that we're live and it throws it into their little algorithms and they'll be like, oh my gosh, we're like a cool, fun place to hang out. Okay, so let's do that. And while you all are doing that, I'm going to pull up this document because I forgot to do that. Only I've been streaming already for 2 hours today. You think I'd have it together, but I do not. I do not. All right, so we got this bad boy here. By the way, it's 46 pages. So buckle up because they're going to be laying out all the reasons why they think this should happen. So I'm very excited about that. Yep, that's right. Be like Angie and hit the like button. Hi, Kelly. Welcome back. Welcome back. Glad you made it. All right. So this was filed. Okay. I guess it was filed yesterday because today's the 18th. But either way, I just found out about it. So I don't know if it just became news today or what happened. I had a very crazy day yesterday. So I don't know. But we're here. So that's all that matters. Glad I could help, Terry. Glad I could help. All right. So this is Karen Reed has filed this against disgraced former trooper Michael Proctor, Sergeant Yuri Bukhenik, Lieutenant Brian Tully, and Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins. Oh boy. Oh boy. Oh, I love this. I love this for us. Love this for us so much. I can't wait to hear what Karen's lawyers are laying out here. Maybe it's some new stuff. It may not be. It may just be everything we've learned from the trials, but maybe not. I don't know. We'll see. Yes, Christy, I did hear about that. Brian Walsh has pleaded guilty to disposing of his wife's body and eluding police. However, did not plead guilty to murder. He's still going to trial for murder. And I'm just like, bro, let's just, why? Yes. So that news just dropped this morning because they're starting jury selection today. That trial is supposed to be December 1st. I will not be covering that trial live. Unfortunately, I do not have the time to commit to that, with it being the holiday season and the other long list of projects I have. But I am thinking about some other ways I might be able to give you guys some info about that, but I'm still working on it. So we'll see. We'll see how that goes. All right. So let me take a drink of my coffee and let's get into this tea, shall we? All right. So, introduction. For 3.5 years, plaintiff Karen Reed was wrongly accused of homicide and subjected to suspicion, arrest, 2 prosecutions, and public condemnation, all resulting from the gross misconduct of the Massachusetts State Police and those working in tandem with the MSP to shield from liability the party or parties responsible for the death of Boston police officer John O'Keefe III. Now, after being acquitted of all charges relating to Mr. O'Keefe's death, Ms. Reed brings this action to recover for and address the actions of those actually involved in Mr. O'Keefe's death and the law enforcement officers who objectively failed to ensure that justice was sought and served in the aftermath of January 29th, 2022. Karen Reed did not kill her then boyfriend, Mr. O'Keefe. Rather, in the early mornings of January 29th, Mr. O'Keefe was killed in defendants Brian and Nicole Alberts' home at 34 Fairview Road in Canton, also will be known as House, in an altercation during a late night house party with other defendants, collectively will be called the House defendants, after a night of heavy drinking. Oh boy. Are we going to follow this one, Dave? Oh, bet your bottom dollar we're going to. Bet your bottom dollar we're going to follow this civil case, though it looks like it's going to be taking a long time, but I'll get to the layout that they gave after we're done reading all over this. But yes, we will be following this extensively. So, the House defendants responsible for Mr. O'Keefe's death, some of whom had professional experience with police investigations, concocted a plan immediately after the altercation to avoid culpability and to frame Karen Reed. Rather than call first responders for help, among other actions, the House defendants conducted a Google search for information about house long to die in the cold. Oh, our favorite phrase. Thanks, Jen. Moved Mr. O'Keefe's body outside and placed him on the Alberts front lawn near the road to make it look like Mr. O'Keefe was hit by a vehicle and that he died in the snow without ever coming into the house that night. Mr. O'Keefe's body remained on the Alberts lawn until Karen Reed found him later in the morning. From the beginning, investigators from the MSP allowed the House defendants to direct the investigation away from themselves and towards Miss Reed. The House defendants were a well-connected and close social group with strong ties to law enforcement. The Alberts were a prominent family in Canton, and the investigative police officers knew them well. Oh boy, yes they did. Yes, they did. Hi, lady. Hello. Welcome. Welcome. I'll do my best to try to pay attention to chat, but I can't make any promises. The lead investigator for MSP, Michael Proctor, grew up in Canton and resides there to this day. He has been and remains close personal friends with the Albert family, House defendant Brian Albert was a longtime Boston police officer, and House defendant Brian Higgins was an agent with the Bureau of Alcohol, Tobacco, Firearms, and Explosives. Boy, are they well connected. Okay. Adhering to the unwritten rule of protecting their own, Proctor and his MSP colleagues intentionally disregarded the obvious and compelling evidence tying the House defendants to Mr. O'Keefe's murder. Specifically, Mr. O'Keefe's injuries were consistent with a physical altercation. He had bruises and lacerations on his face and a deep gash in the back of his head, suggesting that he was punched and fell backwards, hitting his head on a ridged surface. Oh. He also had dog bite wounds and scratches on his right arm and forearm. Equally evident, Mr. O'Keefe did not have a single injury consistent with being struck by a vehicle. He did not have any broken bones or even a bruise on his legs, feet, arms, shoulders, torso, back, ribs, or anywhere below his neck that a medical examiner would otherwise expect to find on a person struck and killed by an impact from a 3-ton vehicle. And to erase any doubt, the Commonwealth's own medical examiner, the pathologist who conducted the autopsy for the Commonwealth, concluded that Mr. O'Keefe's body showed no signs of a vehicular strike. Despite that, Proctor and others shielded the House defendants by intentionally sidestepping fundamental investigatory procedures. Propelled by the House defendants' false statements, including that Mr. O'Keefe never went into the house, Proctor reported in text messages just hours into the investigation that the House defendants weren't going to get any, quote, shit for this because, quote, he's, Brian Albert, a Boston cop, and that Proctor was determined, quote, to make the investigation cut and dry by bringing charges against the girl. Indeed, Proctor made his intentions clear in writing. Karen Reed had, quote, zero chance of skating. She's fucked, end quote. This pronouncement was a mere 16 hours after Mr. O'Keefe's body was discovered on the Alberts lawn, and Proctor had not even walked into the house. Mm-hmm. So far, we know all this, but I'm loving it. True to his promise, Proctor and his colleagues did not search the house for blood evidence resulting from the gash to the back of Mr. O'Keefe's head, or for fingerprints, or for DNA evidence. Proctor did not search the house despite the fact that Mr. O'Keefe was discovered without a winter coat, without the hat that several witnesses said he had been wearing that night, and without his left shoe. At Proctor's direction, the house was never processed by a criminalist or even photographed. No member of the MSP, including Proctor, set foot inside 34 Fairview for nearly a week. The police did not examine or take evidence from the Alberts German Shepherd that was in the house on January 29th, a dog that had a history of attacking other dogs and people. Hi, Savage. Neither Proctor nor any of the MSP troopers conducted physical examinations of the house defendants for evidence of involvement in the altercation, such as marks on their hands, knuckles, or face, or bruises on their body. They did not seize or search the house defendants' phones. They conducted only perfunctory unrecorded conversations with Proctor's friends and acquaintances without any attempt to corroborate their stories. They permitted would-be witnesses to communicate with each other and coordinate their stories before any formal interviews. They allowed critical evidence to be manipulated in some instances and outright destroyed in others. In short, by focusing the investigation solely on Ms. Reed as publicity as implicitly directed by the House defendants through the misrepresentations they made to police. Proctor and his colleagues disregarded and failed to obtain pertinent interviews and other critical evidence from the House defendants that cannot now be recovered or recreated. All right, just a second. Miss Zoe needs to go outside, and she just woke up, so she actually has to go outside. So let me just pause this for just a second. I'll play you guys some music. I can't guarantee it's good, but it's what we got. So just, I'll be right back. All right, so sorry about that, friends. She just woke up today, so, you know, what are you going to do? All right, let's get back into this, shall we? Okay. Nickelback has fallen off. Okay, it was perfunctory. Oh, okay. I don't know. I've already said like 10,000 words this morning, so you'll have that. All right, so here we go. Proctor also secretly communicated with the Alberts on his personal phone, deliberately back-channeling those communications to circumvent his state-issued device and used his sister as a conduit. For instance, on multiple occasions, Proctor disclosed critical and confidential information about the investigation to his sister, who passed that information to her close friend, Julie Albert, Brian Albert's sister-in-law. Julie Albert then passed the same information on to the rest of her family and the House defendants. Part of these communications included Julie Alberts promised to buy Proctor a thank you gift for handling this investigation in a manner that intentionally avoided implicating the House defendants and singularly focused on Ms. Reed. Thank you, Terry. I told the Llama nerds when we were learning earlier that I wore this today because I felt like I was going to be sassy. And so, I mean, if you're going to be sassy, then you need the animal print. Am I right? Am I right? All right. Proctor then went so far as to manufacture evidence to ensure that Ms. Reed, not his friends and fellow law enforcement officers, was blamed for Mr. O'Keefe's death. This included planting evidence at the scene on Mr. O'Keefe's clothes and on Ms. Reed's vehicle to support the false narrative that Ms. Reed hit Mr. O'Keefe with her car, even though he knew Mr. O'Keefe's injuries were inconsistent with a motor vehicle strike and consistent with a physical altercation and dog attack. Far from conducting an objective investigation with integrity, Proctor personally sexualized and dehumanized Miss Reed throughout the investigation. Specifically, Proctor's private communications to his high school buddies, sister, and MSP colleagues that he believed would never be discovered. Mistake. Exposed the corruption and bias at the core of MSP's entire investigation. Specifically, only hours into the investigation, in a text chain with 8 of his high school buddies, Proctor stated that Miss Reed is a whack job, see you next Tuesday, retarded, a nutbag, and a, quote, a babe with no ass. What a classy guy, that Proctor. Just so classy. Proctor further ridiculed and derided Miss Reed for her serious medical condition, stating that her balloon knot leaked poo. In other private text messages to his MSP supervisors and colleagues, Proctor bragged that while conducting a search for Miss Reed's phone, he was looking for naked pictures of Miss Reed. Disappointed, he reported that there were, quote, no nudes so far. In an unfiltered utterance, Proctor revealed his true mindset, quote, hopefully she kills herself, end quote. I think who needs a bum doctor? Oh man, this guy. I hate that guy. What a shame. Indeed, Proctor's supervisors and MSP knew about and condoned Proctor's unlawful conduct, and in some instances expressly encouraged this flagrant abuse of power. For example, on one occasion, Proctor's immediate supervisor, Yuri Bukhenik, responded with a thumbs up emoji to a text calling Ms. Reed retarded. But remember, guys, he didn't really read it. He just reacted because he was busy working at the airport or something. Remember, that was his excuse. Well, I didn't really know what it said. I just gave that. So he knew that it was read, not that I approved of what he said, because that's what people do, but they don't do that. No. Proctor's supervisors and the MSP knew Proctor had a close relationship with the Alberts and that he made no secret of his bias against Miss Reed, demonstrating a clear prejudice against her from the outset. Relying on manufactured evidence, actively ignoring exculpatory evidence, and without investigating obvious signs pointing towards the House defendants, the Commonwealth secured 2 separate arrest warrants for Ms. Reed and a knowingly baseless indictment against her, and then wrongfully prosecuted her for murder twice. As alleged below, these unlawful acts not only underline plaintiff's meritless wrongful death claim against Miss Reed, but they also form the foundation for Miss Reed's claims against the defendants. These acts violated Miss Reed's state and federal constitutional rights, the Massachusetts Civil Rights Act, and well-established Massachusetts tort principles. He was on traffic duty at the airport, though, right? I think it was that, at the airport. Ooh, bro. On June 18th, 2025, after a 2-month trial, a jury rejected the Commonwealth's theory, in part because the overwhelming physical, scientific, and medical evidence established that Ms. Reed's vehicle did not strike Mr. O'Keefe and that Mr. O'Keefe's injuries did not come from a vehicle strike. Although Ms. Reed was ultimately and finally acquitted of all charges related to the death of Mr. O'Keefe, Proctor was fired, and nearly every MSP officer in Proctor's chain of command was disciplined for their egregious abuses and misdeeds. The Commonwealth still has not sought or provided justice, not to the O'Keefe family, not to the community at large, and certainly not to Ms. Reed. That's true. Facts. Hi, Justice Jane. Hi, hope you're doing well, babes. Welcome. Welcome. We're only on page 6 of 46, so boy, is there going to be a story here. In response, the Commonwealth has offered only empty platitudes instead of solutions. The head of MSP, Colonel Jeffrey Noble, stated, quote, "The events of the last 3 years have challenged our department to thoroughly review our actions and take concrete steps to deliver advanced investigative training, ensure appropriate oversight, and enhance accountability. Under my direction as colonel, the state police has and will continue to improve in these regards." Isn't that cute? Isn't that cute? In an interview with the Boston Herald, Noble acknowledged that systemic nature of MSP's conduct in Ms. Reed's case, quote, "I'm eyes wide open to a culture issue that I have concerns with as it relates to Trooper Proctor." Sir, he's not the only one, okay? Okay, just saying. These hollow words do nothing to right the devastating wrongs that had been visited on Ms. Reed. Colonel Noble's words confess a sickness deep in the marrow of the MSP, but offer no remedy, no medicine, no relief to someone so brutally victimized by it. And I'm sure there's numerous others. On Wednesday, March 19th, 2025, following the public disclosure of Proctor's illegal and unethical conduct related to the Reed investigation, the MSP's trial board found Michael Proctor guilty of a Class A violation, which included, quote, that he was biased in his dealings with a homicide suspect and or brought otherwise himself and the Massachusetts State Police into disrepute. Miss Reed's life was not merely turned upside down by the MSPs and the House defendants' misconduct. It was forever changed by the defendants' transgressions and wrongdoing. The years of uncertainty and unimaginable emotional distress have left lasting scars that will never heal. At the same time, neither Mr. O'Keefe nor his family has received justice. His killer or killers still walk free. By asserting her claims against MSP Proctor, his supervisors, the town of Canton, and the House defendants, Miss Reed seeks at minimum to confront and redress these wrongs and others. More importantly, she seeks to force the Commonwealth to fulfill its duty to stop law enforcement from trampling the innocent to protect their own. Part 2, Parties. Plaintiff Karen Reed is an individual residing in North Dighton, Massachusetts. Defendant Michael Proctor is a former Massachusetts State Police trooper, disgraced, residing in Canton, Massachusetts. He is being sued in his personal capacity. Defendant Sergeant Yuri Bukhenik is a Massachusetts State Police trooper residing in Stoughton, Massachusetts. He is being sued in his personal capacity. Defendant Lieutenant Brian Tully is a Massachusetts State Police trooper residing in Hingham, Massachusetts. He is being sued in his personal capacity. Defendant Brian Albert is an individual residing in Norwood, Massachusetts. Defendant Nicole Albert is an individual residing in Norwood, Massachusetts, because remember they moved and sold the house because that was normal. Defendant Jennifer McCabe is an individual residing in Canton, Massachusetts. Defendant Matthew McCabe is an individual residing in Canton, Massachusetts. And defendant Brian Higgins is an individual residing in Sandwich, Massachusetts. Who here is excited to see Matthew on the stand again? Oh, that guy. Oh, Matt McCabe, you were something. I'll tell you that. Can't wait. Jurisdiction and venue. This court has jurisdiction over all claims in the case pursuant to a case and with regard to the federal claims pursuant to Resnick versus Chief of Police. Venue is appropriate in this court pursuant another thing because at least one party to this case, Plaintiff Karen Reed, resides in Bristol County. Facts common to all counts. Mr. O'Keefe's death. Before his death, Mr. O'Keefe and Ms. Reed were dating. On the evening of January 28th, 2022, Mr. O'Keefe and Ms. Reed went out for the night. They first went to C.F. McCarthy's in Canton, where they had several drinks. They then went to the Waterfall Bar in Canton. There, they met up with a group of acquaintances, including Brian Albert, his wife Nicole Albert, Brian's brother Chris Albert, and his wife, Julie. Jennifer McCabe, Nicole's sister and Brian's sister-in-law, her husband, Matthew McCabe, and Brian Higgins. The group of acquaintances had several drinks and planned to continue the party back at the McAlberts home in Canton at 34 Fairview Road. House defendant Jennifer McCabe told John O'Keefe that he should come to the house. The group had overlapping social relationships. At the time, Brian Albert was a Boston police officer, as was Mr. O'Keefe, though they did not know each other well. Brian Albert and Brian Higgins were close friends. Higgins was an officer with the ATF. He also was permitted to keep an office at the Canton Police Department alongside Brian Albert's brother, Canton Police Detective Kevin Albert. Kevin Albert had a professional and social relationship with Michael Proctor. Oh boy. Brian and Nicole Albert's son, Brian Albert Jr., and his friends were already at the house for Brian Jr.'s birthday. In addition, Colin Albert, Brian Albert's nephew, was present. Ms. Reed and Mr. O'Keefe had never been to the house before January 29th, 2022. They arrived in front of the Alberts' home around 12:20 a.m. Miss Reed was reluctant to attend the party for several reasons, including that she was unsure whether they were at the correct location and whether they were even welcome to the late-night party. Mr. O'Keefe got out of Miss Reed's SUV and indicated that he would check out the party and report back to her. Let me adjust my seat, my blanket a little bit because I'm kind of cold. It's cold today, guys. Let's see. Mr. O'Keefe walked towards the front door, garage door area of the house and entered one of the two doors. A period of time passed without any word from Mr. O'Keefe. Ms. Reed, who was still hesitant to join, presumed that Mr. O'Keefe intended to stay, and therefore she left to go home without him. At some point after entering the house garage, Mr. O'Keefe was involved in a physical altercation either inside the house or garage. During that altercation, the Alberts' German Shepherd attacked him, and Mr. O'Keefe sustained multiple dog bites and scratches on his right arm. He also suffered an incapacitating contrecoup wound on the back of his head. Mr. O'Keefe's head wound was caused by falling backward and striking a ridged surface. The Alberts garage contained such surfaces. By contrast, the head wound could not have been caused by a vehicle strike or falling backward onto a flat, cold lawn like the Alberts. Because of their knowledge of criminal investigations, the Alberts, the McCabes, and Higgins knew that calling for medical care to help save Mr. O'Keefe's life would trigger immediate and irreversible risk of their own criminal exposure. Therefore, at least the five of them agreed on a simple plan to exonerate themselves and implicate Ms. Reed. They would tell anyone who inquired Mr. O'Keefe never entered the house and hide evidence that he was there, including his body. Sometime during the night, they repositioned a Ford Edge vehicle at a spot adjacent to the front lawn, which obscured the view of that area of the lawn from potential passerby. At some point further in the night, they carried or dragged Mr. O'Keefe's body to the same area in the yard, close to where one or more of them later claimed Miss Reed dropped off Mr. O'Keefe earlier that night. The plan was devised to make it appear that Mr. O'Keefe had been struck by Miss Reed's vehicle and then died as a result of exposure to the cold. Mr. O'Keefe was either dead when the house defendants left him on the Alberts lawn, or he died shortly after. After the physical altercation, Higgins left the house and drove to Canton Police Department in the middle of the night, as one does when there's a blizzard happening. And he's been drinking all night, so okay. He later told investigators he had to do some administrative work, but then changed his story subsequently, stating that he drove to the station because he had to move cars in the parking lot due to the snowstorm. However, video from inside the station shows Higgins walking down the hallway and surreptitiously entering offices while wearing a hoodie to obscure his face. Surveillance video outside reveals Higgins transporting a large bag from one vehicle to another before driving away. After leaving the police station, Higgins and Brian Albert continued to coordinate their stories by calling each other multiple times in the early morning hours, and ultimately spoke with each other on their cell phones at 2:22 a.m. Later, both Brian, Albert, and Higgins denied the existence of these phone calls, and then when confronted with their existence by a separate law enforcement agency, a non-MSP and non-CPD law enforcement agency, also known as the FBI, at a separate proceeding, they coordinated the same exact lie, falsely claiming the multiple calls and answers were just butt dials. That's right, just butt dials, guys. However, 5 minutes after the Higgins-Albert call, Ms. McCabe performed a Google search on her phone at 2:27 a.m. Haas long to die in cold, misspelling the first word, which will live forever in infamy. And I couldn't be more joyous about that, to be honest. Actually, that was me. I don't know. I just pick a random one that's in StreamYard. We're working on coming up with something cooler, though. We only get like 8 choices. All right. So, Ms. Reed searches for Mr. O'Keefe. Ms. Reed began the search for Mr. O'Keefe on January 29th, just before 5 a.m., when she awoke and realized he had not returned home. She phoned house defendant Jennifer McCabe, who already knew exactly what had happened to Mr. O'Keefe. Ms. McCabe insisted that Ms. Reed drive to McCabe's house rather than driving to 34 Fairview Road, which Reed did. The two of them were then joined by Carrie Roberts, and the three of them left the McCabe residence. However, rather than go to 34 Fairview, oddly, Ms. McCabe directed them to go back to Mr. O'Keefe's home, where Ms. Reed had just come from. After the three of them finally drove to 34 Fairview, the illogical McCabe directed route to 34 Fairview was intentional. It allowed the House defendants more time to finish creating the scene and hiding evidence before Mr. O'Keefe's body was discovered on the Alberts lawn and first responders arrive. Nice. Nice. We do have like an epidemic sound account as well. I don't know if that's the same thing, but yeah, shoot them over to Amos's way. That'd be awesome. Thank you, Savage. As they approached the house, with Ms. Roberts driving, Ms. Reed saw Mr. O'Keefe almost immediately. She screamed for Ms. Roberts to stop the vehicle and jumped from the moving car to run to Mr. O'Keefe. Please see Buffy's reenactment under our video section on our channel. It's fantastic. She began rendering aid, including CPR. As the House defendants had planned, Mr. O'Keefe's body was discovered in front of the Alberts house near a flagpole and fire hydrant on the left side of the Alberts property as seen from the roadside. Excuse me. The Ford Edge, which had been parked in a position to obscure Mr. O'Keefe's body in the middle of the night, had been removed. While Ms. Roberts joined Miss Reed with administering CPR, Ms. McCabe did not help or even approach Mr. O'Keefe, her bestie. Rather, she sat in the cab of the vehicle, called 911, and reported that, quote, "There's a man passed out in the snow." Just a man, not her friend, John O'Keefe, just a man. Despite knowing that her brother-in-law, Brian Albert, a police officer and first responder, was just feet away inside the house, Ms. McCabe never went into the house or requested that Albert come down to help Mr. O'Keefe. Rather, as Mr. O'Keefe lay dying in the snow, Ms. McCabe stood and watched with no fear, urgency, or even concern for her family members residing mere feet away. It's weird, Jen. It's weird. Okay? It's weird. Investigation begins. The CPD were the first on the scene shortly after 6 a.m. At the time, there was no evidence that Mr. O'Keefe had been hit by a vehicle. In fact, the evidence suggested just the opposite. His body did not show signs of trauma commonly associated with being struck by a car. There were no bone fractures or trauma to his lower body, his torso, or any other part of his body, as investigators would expect from a vehicle strike. Rather, Mr. O'Keefe's injuries were consistent with being physically assaulted to the face and head and attacked by a dog. For good reason, the ranking CPD officer on the scene, Sergeant Michael Lank, opined on a telephone call captured on a dash cam that Mr. O'Keefe looked like he had been in a fight. I mean, yes. Moreover, Moreover, the initial search conducted by Canton police officers revealed that there was no vehicle debris on the lawn at 34 Fairview, let alone any debris at or near Mr. O'Keefe's body. Not a single piece of tail light material was discovered on the lawn that morning or in the roadway, notwithstanding multiple searches and the use of a leaf blower to remove snow. Tellingly, despite the commotion outside, including more than a dozen first responders, 3 police cruisers, 2 ambulances, a ladder fire engine, all with their emergency lights flashing, and at least 2 civilian vehicles, plus Miss Reed's screams upon finding Mr. O'Keefe's body, no one from the Alberts house, including police officer Brian Albert, ever went outside to see what was happening, let alone help. They wanted to avoid scrutiny from the police investigators. Sergeant Link was a longtime friend of the Alberts and the first law enforcement officer to enter the house. He spoke to the Alberts and the McCabes. Pursuant to their plan, the Alberts and the McCabes told Sergeant Link that Mr. O'Keefe had never entered the Alberts' house the night before. The Alberts and McCabes' statements were false. Mr. O'Keefe arrived at and entered the house or garage where he was assaulted, attacked by the Alberts' dog, and suffered a fatal injury to the back of his head. Despite Mr. O'Keefe's injuries being wholly inconsistent with the story of the House defendants were now telling him, neither Sergeant Link nor any other member of the CPD searched the house to determine whether the occupants or anyone else were involved in Mr. O'Keefe's death, nor did they request to search the occupants' cell phones, observe their bodies for evidence of a fight, or even secure the scene where Mr. O'Keefe's body was found. They failed to do so because of the bias born of friendship and loyalty in favor of the Alberts and McCabes. After Sergeant Link returned to the CPD 3 hours after the discovery of Mr. O'Keefe's body, and more than 2 hours after being interviewed at the Alberts' home that morning, Ms. McCabe called Sergeant Link to report that she recalled additional information. Oh, I just remembered. Oh, jeez. Yes, Angie put Buffy's link to her Jen McCabe reenactment in the chat there. If you haven't seen it, go check it out. That was a fun time. As part of the plan to implicate Ms. Reed and remove suspicion from the House defendants, she falsely told Sergeant Link that Ms. Reed told her twice that morning, quote, "I hope I didn't hit him," end quote. More than a year later, at a separate proceeding, Ms. McCabe changed her story on this topic yet again. In furtherance of the House defendants' plan, McCabe then falsely reported that Ms. Reed outright confessed to hitting Mr. O'Keefe right after she first found him in the snow. Jen. There's a lot of trains today. Oh my goodness. Busy day. Let's see. Where was I there? I'll just wait for this train. All right. Proctor leads MSP investigation despite conflicts. Michael Proctor was assigned as the case officer and had primary responsibility for the MSP investigation of Mr. O'Keefe's death. Sergeant Yuri Bukhenik was Proctor's direct supervisor. Lieutenant Brian Tully was the supervisory officer at the Norfolk County State Police Detective Unit and thus supervised both Bukhenik and Proctor. In their roles, Bukhenik and Tully both knew at all times exactly the extent of Proctor's misconduct in investigating Mr. O'Keefe's death, as described below. Okay. I'm just a soccer mom. I'm just a soccer mom. I didn't lie. Jen. Oh, man. From the beginning, excuse me. From the beginning, Proctor should never have been assigned as an investigating officer, let alone the lead investigator. He grew up and resides in Canton, is a good friend of the Alberts, and had known the family for years. Proctor and Julie Albert, Brian Albert's sister-in-law, had each other's personal cell phone numbers. In fact, just days before Mr. O'Keefe's death, Proctor communicated with Julie Albert about babysitting Proctor's minor child. Proctor's sister, Courtney, was also a close friend of Julie. In fact, Proctor's own mother referred to the Alberts as the Proctor's second family. The existence of these relationships was intentionally suppressed by Proctor and other members of the MSP, including Bukhenik and Tully, in an effort to ensure that the House defendants were protected and that Ms. Reed's right to a fair investigation and trial were undermined. Next section, Proctor, Bukhenik, and Tully engage in a corrupt and biased investigation. by not investigating inside the house and interviewing house defendants as friends rather than suspects. Proctor, Bukhenik, Tully, and the MSP never searched for DNA evidence inside the house, never looked for ridged surfaces that could have caused the gash on the back of Mr. O'Keefe's head, never inspected the house defendants' bodies for indication of bruises or cuts that resulted from an altercation, and did not search the house defendants' cell phones. I mean, even we know to do all of this. It's crazy. I was thinking the same thing, Ange. I was like, oh, that's interesting. That's interesting. But, I mean, you can always add people, I guess. Maybe it's just not a surefire with him and they just don't want to, risk it or something. I don't know. Sorry. This allowed potential evidence to be destroyed, disposed of, removed, or simply become unrecoverable. Proctor's, Bukhenik's, and Tully's interview of the house defendants were also outside of normal protocol. They were all interviewed either at their home, their family member's home, their lawyer's home, in the case of Brian Higgins, their lawyer's office, in the case of Brian Jr. and Caitlin Albert, their place of employment, or over the phone. These interviews were each untimely, unrecorded, and fundamentally designed to protect the house defendants, and the house defendants took full advantage of it. I mean, how do you not record a single one of these? I just don't understand. Specifically, Jennifer McCabe became the point person for the house defendants in providing their false narrative to investigators. She managed and communicated details about the house defendants' messaging and the investigation itself, including visiting Proctor's and other investigators' private residences, mapping out timelines to coordinate statements with other witnesses, leading group text message chains that were later partially deleted, and planning private meetings at all hours of the day and night. Indeed, there were never the acts of innocent witnesses seeking to help an investigation concerning the death of an alleged friend. Rather, they were predicate acts of a conspiracy among a group of people with a shared goal of deflecting their criminal exposure onto someone else. The remaining group texts that were not deleted or that were recovered later reveal some of their planning. For instance, on the evening of January 29th, Jennifer McCabe texted with her sister Nicole Albert that Carrie Roberts, who was present when Mr. O'Keefe's body was found, talked to cops and kept it simple. Of course, there would be no reason to report back to other house defendants about Roberts keeping it simple unless what really happened was more complicated. Proctor, Bukhenik, and the MSPs never sought these communications. Rather, they were obtained by Karen Reed's defense attorneys, repeated motions to compel access to data on Ms. McCabe's iPhone. Later, in group text with Jennifer McCabe and Brian and Nicole Albert, Matthew McCabe suggested having Chris Albert publicize their crafted story to a reporter, saying, "Ask Chris to ask some questions. Tell them the guy never went in the house." As an endorsement of the plan, Brian Albert responded, "Exactly." And remember, in case you don't, Jen and Matt were actually friends with John. Of all these people, Brian too, but Higgins, not Brian Albert and Nicole, though. Importantly, the text messages from the house defendants' phones that were ultimately recovered and that provided a window into their conspiracy and misconduct, as well as MSP's unlawful investigation, were not the product of CPD or MSP's investigative work. Rather, based on media reports raising serious questions about MSP's investigation and the house defendants' role in Mr. O'Keefe's death. Another separate law enforcement agency, FBI, began its own subsequent investigation. That investigation, and not MSP's, resulted in obtaining the House defendants' phones, taking statements from the House defendants, and conducting a separate proceeding, all of which MSP refused to do itself. Indeed, the evidence procured by the separate law enforcement agency's investigation demonstrates the House defendants' conspiracy and unlawful conduct, as well as MSP's bias and corruption. Why can't they just mention now that it's the FBI at this point? Like, I've seen the FBI mentioned in tons of court stuff. Like, why are we still not saying who it is? Unless I'm forgetting that this is a different entity, but still, why are we still doing this? I don't understand. Okay. Proctor and Bukhenik initially interviewed the McCabes and Brian Albert on January 29th at the McCabes' home at 12 Country Lane in Canton, at which time they again falsely stated that Mr. O'Keefe never entered the Alberts' home. Bukhenik and Proctor did not interview Nicole Albert and Brian Higgins until February 3rd, 2022, and did not interview Chris and Julie until February 10th, nearly 2 weeks after Mr. O'Keefe's death and more than a week after Miss Reed was arrested and charged. Before both interviews, the McCabes and Alberts continued to coordinate their stories as evidence in group text. Proctor, Bukhenik, and Tully likewise failed to conduct a meaningful investigation into Higgins' involvement. When Proctor and Bukhenik interviewed Higgins on February 3rd, Higgins presented the troopers with a select set of self-curated texts between himself and Ms. Reed. They learned that Higgins and Ms. Reed had been exchanging flirtatious texts and that Higgins reported at least one instance in which Ms. Reed and Higgins had kissed while at Mr. O'Keefe's house mere weeks before his death. Oh, is that why? But okay, I don't know. I don't understand this part of the whole thing. Like, we all know. Just say it. Okay. Rather than pursuing Higgins as a possible suspect, Proctor, Bukhenik, and Tully neglected to investigate the matter further. They never interviewed Higgins again, even after surveillance video revealed Higgins was suspiciously hiding his face in the halls and the parking lot of CPD at 1:30 a.m. on January 29th. The video contradicts Higgins' statements about his actions that night. However, not only did Proctor, Bukhenik, Tully, and MSP not investigate what Higgins was doing or what was in the bag, but they went so far as to hide this video from Karen Reed and her criminal defense attorneys for years. Reed's defense did not receive these videos until after Reed stood trial for the first time. And even after the separate law enforcement agency's investigation revealed late-night phone calls between Brian Albert and Brian Higgins, MSP failed to pursue either witness further or seek a full forensic extraction of Higgins' phone or even a simple call log from his cellular provider. When it was revealed that Miss Reed's defense team requested the preservation of Brian Alberts and Higgins' phones in order to forensically image them, this request was allowed by the court. Both men got rid of their phones within days of one another. Oh, what a coincidence. Higgins went so far as to drive to a military base on Cape Cod, remove the SIM card from the phone, cut the SIM card with scissors he brought with him, and destroy and dispose of the phone and cards separately in 2 dumpsters, and then drive back home, as one does. Their destruction of their phones eliminated potentially incriminating communications between them and was a direct result of Proctor's, Bukhenik's, and Tully's intentional refusal to collect important investigative evidence that would be exculpatory to Ms. Reed. Even after learning about the destruction of both witnesses' cell phones, MSP investigators had other avenues they could use to pursue evidence, such as cellular toll records or simply interviewing Brian Higgins and Brian Albert to inquire about the nature of the late night communications. They intentionally ignored these avenues as well. Not only did Proctor fail to probe his friends' stories, he coordinated with them through his sister. Proctor spoke to Courtney multiple times a day and knew she was in close contact with and providing information to Julie Albert. Julie and Courtney called each other many times between February 1st and 2nd, and at least 67 times between February 1st and September 6th, 2022. For example, as he prepared to question Chris and Julie Albert on February 10th, Proctor told his sister Courtney that the interview was not a big deal. Courtney told Proctor that Julie Albert had been nervous and wanted to give him a thank you gift after the interview, as one does. To avoid scrutiny, Proctor instructed Courtney to tell Julie to give the gift to his wife, Elizabeth Proctor. Proctor shared investigatory details with Courtney before they were public. In the same instance referenced above, when his sister informed him that Julie Albert had been so nervous before the interview, instead of investigating further, he shrugged it off, laughed, and asked why. But Proctor knew exactly why Julie Albert was nervous. He sought to reassure her by telling Courtney that it was fine, just a quick convo. And then, after the interview, Proctor spoke to Julie on his personal cell phone in an unreported conversation. Ooh, not great. Not great. Proctor never treated the Alberts as witnesses in a murder investigation. He treated them like the family friends that they were. Right? Right, Savage? Nothing to see. Move along. Everything's fine. This is totally normal and great. What do we got here? Oh, thank you for that. I'll be sure to read that, Ange. Thank you. Okay. Oh boy, this is so messy. It's just getting messier and messier, and I love it. I love it so much. Okay. At one point, leading up to the sum of the interviews, Ms. McCabe asked Nicole Albert if she had heard anything more about the investigation. Confident she would learn more from Julie Albert, again through Courtney, Nicole Albert responded, "We'll get more info tomorrow. Don't want to text about it." House defendants did not want to text about their activities and communications because they tried to hide and or lie about them. For instance, it was discovered in the second criminal trial that Ms. McCabe had lied in her sworn testimony in the first trial about not visiting 34 Fairview with Carrie Roberts on January 30th on their way to Michael Link's house. However, while they did not text about this meeting, McCabe's cell phone location data, obtained later by Reed's defense, reveals that she did, in fact, visit 34 Fairview just one day after O'Keefe's death and lied about it. The McCabes, Alberts, and Higgins all told the same false story to investigators in their interviews, and Proctor, Bukhenik, and Tully accepted their coordinated statements without making efforts to corroborate their stories. All right, before I do this next part, guys, I'm sorry. I do have to refill my coffee because my throat's really dry and getting scratchy. So that'll help. So I will be back in just a minute. I won't play the same music. I'll play a different one. Let's do Feeding the Ducks. That's what it's named. I don't know if it really makes me want to feed the ducks, but apparently this should get you in the mood for this. So give me just a minute. I might have to reheat my coffee too. I don't know if the coffee maker's off or not, but I'll be right back. Thanks again for being patient, friends. I even grabbed a soda too, so I shouldn't have to get up again, but reading for 2 hours out loud before this makes my throat a little scratchy. So, but we're already like halfway through this. I have like this dog hair that keeps like attacking me today. I don't know what that's about, but dogs. Oh, what does it mean though? Oh, of course you comment on that music. I'm sorry. All right, where were we here? Okay. Rather than investigate their friends and brethren, Proctor, Bukhenik, Tully, and MSP target Karen Reed. Oh, okay. Instead of taking the routine, objective, and necessary steps of investigating the McCabes, Higgins, and the Alberts, Proctor, Bukhenik, and Tully focused exclusively on Miss Reed as a suspect from the start of the investigation, despite substantial evidence exonerating her and implicating others, just as the House defendants intended. Proctor seized Miss Reed's cell phone and her SUV within 30 minutes of interviewing her on January 29th. He arrested her 72 hours later before reviewing any surveillance from the bars or ring camera footage, before interviewing exculpatory witnesses, and before the medical examiner's official conclusion that the manner of death could not be determined and that there were no injuries to Mr. O'Keefe's body consistent with a vehicle strike. Excuse me. Much to Proctor's surprise, through the separate law enforcement agency's investigation, his contemporaneous text messages were discovered. Among them, Proctor texted with his high school friends on the evening of January 29th, the day he began his investigation. He told them that the MSP had already determined the Alberts were not going to receive any scrutiny about Mr. O'Keefe's death, even though the MSP had not at that point visited the crime scene or been inside the Alberts' home and had performed only a cursory interview of the McCabes and Brian Albert. Lady and Grace says, I wonder if the McCabes understand what discovery will be like for their defamation filing. Even their children's Allie and Colin phone location data may be included. Yeah, because civil court is not quite the same as criminal court. So, yikes for them. Proctor told his friends that Mr. O'Keefe had been hit by a car and had not been in a fight, despite the fact that Mr. O'Keefe had suffered no injuries consistent with a vehicle strike, but he did have injuries consistent with a fight and dog attack. Proctor rejected a friend's belief that Brian Albert, the homeowner of the property where Mr. O'Keefe's body was found, would receive some shit, instead agreeing with another friend's assumption that you guys, the MSP, are out to make it cut and dry since it involves cops. Proctor revealed that he had already decided he was going to put serious charges on Ms. Reed, that she was fucked, and that there was zero chance she skates. From the outset, Proctor was determined to pin it on the girl. Proctor's supervisors were aware of his bias and conflicted relationships in this investigation. They didn't have to guess. Proctor told them. He told them he knew that Alberts, text messages from Proctor to Bukhenik and other MSB troopers show Proctor had decided to focus suspicion on Ms. Reed to the exclusion of everyone else. He told the troopers that Miss Reed was retarded and that he was searching her phone for nudes of her. In the text chain, Sergeant Bukhenik liked Proctor's text describing Ms. Reed as retarded. Bukhenik. Bukhenik received Proctor's text and never reprimanded Proctor or addressed his improper bias and conduct. Hi, Sankoda. Long time no see. Hope you've been doing well. Happy to have you here. Let's see, where was I there? Oh, we're on the next page. Because he was determined to put serious charges on Ms. Reed, Proctor ignored the fact that the Commonwealth's medical examiner could not conclude that Mr. O'Keefe's death was a homicide, determining instead that the manner of his death could not be determined. The medical examiner also refused to conclude that Mr. O'Keefe died as a result of being struck by a vehicle, and later testified at trial that his injuries were not consistent with a car strike. Proctor later admitted that in his entire career, he had never seen a homicide investigation where the medical examiner could not determine the manner of death. Sir, okay. But he remained undeterred in his quest to charge Ms. Reed. As he later admitted, the medical examiner's refusal to rule the death a homicide did not matter to him because either way, Ms. Reed was going to be charged. Gosh. Yikes. Yes, everybody be like, Angie. And give the show a like. That'd be great. Proctor Bukhenik plants certain evidence and make false statements in court and other legal documents to frame Karen Reed. Proctor made this investigation cut and dry by manufacturing a case against Miss Reed. A crucial first step was to ensure that the crime scene and evidence was not secured. This was in violation of MSP policy and well-established best practices for critical incident investigations. Specifically, the MSP crime laboratory requires proper processing of evidence at major crime scenes, including crime scene photography and evidence processing and recovery of latent fingerprint, footwear, and tire track evidence. Neither the MSP troopers involved in the investigation nor the CPD police officers on the scene secured the Alberts home or the area where Mr. O'Keefe's body was found. The MSP did not take any photographs of the house, including any part of the yard where O'Keefe's body was found, until February 1st, more than 3 full days later. No photographs were ever taken of the inside or garage of 34 Fairview. This intentional departure from established protocols permitted Proctor and Bukhenik to generate false, incriminating evidence against Miss Reed and give the House defendants time to destroy the actual evidence. By approximately 2:30 p.m. on January 29th, before he had even met or interviewed Miss Reed or seen her Lexus SUV, Proctor had already ordered seizure of the vehicle at her parents' home in Dighton. By 4:17 p.m., the vehicle was in MSP's physical possession. The vehicle was then towed to the CPD Sallyport, even though The MSP has at least 2 closer barracks, and Massachusetts was in the middle of a historic nor'easter. Proctor knew he had more leeway to manipulate evidence regarding the SUV at CPD than at MSP's facilities, and he knew he needed to have the evidence in close proximity to the crime scene at 34 Fairview Road. Before the vehicle arrived at the garage, Miss Reed's Lexus taillight had a minor crack, but was intact. The crack occurred when Ms. Reed backed into Mr. O'Keefe's car at 5 a.m. that morning as she was leaving to search for him. That incident was captured on video. Bukhenik and Proctor followed the vehicle from Dighton and arrived at CPD at 5:35 p.m., just moments after the tow truck with the Lexus. At some point after the vehicle arrived at the Sallyport, the right near taillight was almost entirely destroyed. Video taken from different angles in the Sallyport show Bukhenik, Proctor, Canton Police Chief Ken Berkowitz, and other individuals near the taillight. But notably, no video captures the taillight appearance at the precise time it arrived at the Sallyport. The available surveillance video from the Sallyport, as well as CPD access card swipe log obtained by a separate law enforcement agency, reveals seemingly unfettered access to the Sallyport by a myriad of individuals throughout the evening of January 29th, including just before and just after 5:30. One or more of them destroyed the taillight, secretly took pieces of it into their possession, and then planted some of them in various places at 34 Fairview and on Mr. O'Keefe's clothes. Knowing that there were video cameras both inside and outside the Sallyport, Proctor and Bukhenik worked together to obscure their role in manipulating the right rear taillight and then ultimately to present false evidence at the first criminal trial. Specifically, Proctor directed Bukhenik to secure video footage from surveillance cameras located both inside and outside the Sallyport garage, which he did. Those videos were manipulated in 2 significant ways. First, a critical 42-minute portion was deleted from the footage from the Sallyport front wall camera. The portion from 5:08:02 p.m. to 5:50:50 p.m., which included the exact time Ms. Reed's Lexus arrived in the garage. This footage would have shown that the taillight was intact. Second footage from the Sallyport back wall camera was inverted, which made the right side of the Ms. Reed's vehicle appear to be the left side and vice versa. Another camera, main driveway side exterior, captured the back end of the Lexus as it arrived at CPD, but was too grainy to decipher the condition of the passenger taillight. I feel like they still should have had like better cameras too, but okay. All right. So the videos from inside and outside the Sallyport and Proctor's request for Bukhenik to obtain it was intentionally hidden from Karen Reed and her defense attorneys for more than 2 years to avoid scrutiny. The video was then sprung on them immediately before and during the first criminal trial. One driveway camera's footage was not revealed to the defense until just prior to the start of the second trial. I mean, so suspicious. In fact, Bukhenik presented one part of the video during his direct testimony under questioning by the assistant district attorney, Adam Lally. Bukhenik narrated the video to the jury, correctly identified that Proctor was at the rear of the vehicle, but claimed that he never approached the right rear taillight area of the vehicle. That testimony, however, was entirely false, as he well knew the video that Bukhenik authenticated as fair and accurate was actually neither fair nor accurate because it had been inverted. Proctor was actually behind the right tail light for a significant period, but because it was inverted, it appeared in the video that he was behind the left tail light. They hoped this would allow Bukhenik to lie about this issue at trial without detection. With this video and Bukhenek's false testimony, the MSP, Proctor, and Bukhenik attempted to mislead the jury in order to conceal the tampering with and planting of tail light material. Because why else would you do it? Why else? Oh, the more you know, Angie, about feeding the dogs. Okay. Not going to put that up on the screen, but okay. Proctor and Bukhenik also took taillight pieces from the Sallyport, brought them back to 34 Fairview to plant them in the location where Mr. O'Keefe's body was found, and then falsified various documents in an attempt to hide their conduct. In more applications to the Stoughton District Court and Norfolk Superior Court for searches of Google's electronic records, ring videos, Miss Reed's phones, Miss Reed's vehicle, cell tower records, and other sources of information, Proctor swore he seized Miss Reed's vehicle from her parents' home at 5:30 p.m. on January 29th, 2022, and had the vehicle towed to the CPD. Reports shared by the Dighton Police Department in 2023 revealed that the Lexus was towed from Dighton at 4:17 p.m. Proctor's assertion that he seized it at 5:30 p.m. was intentionally false to hide the fact that the car was in police custody for 73 minutes longer than indicated in his sworn affidavits. Proctor maintained that false narrative because it would hide the exact time frame when he had the opportunity to remove pieces of the taillight from Ms. Reed's vehicle and bring them back to the house so that he could later claim the pieces had been there since approximately 12:30 a.m. on January 29th. However, unbeknownst to him, driveway video from the Reed residence in Dighton and a report written by the Dighton Police Report revealed Proctor's lie and revealed the true and accurate time the Lexus SUV came into MSP's possession. Proctor also deposited the SUV taillight pieces that he and others removed from the vehicle in the Sallyport on Mr. O'Keefe's clothes. Proctor retrieved Mr. O'Keefe's clothes from the floor of the hospital where he was pronounced deceased. Instead of securing the clothes in a sealed container or bag, as protocol requires, Proctor and Bukhenik drove them around in his car all day and then placed them in the Norfolk County District Attorney's Office for at least 6 days, where they were accessible to Proctor, Bukhenik, and any other MSP troopers. So, great. Proctor and Bukhenik failed to create a log to document the chain of custody of the clothing. Therefore, and by design, there is no record of when, how many times, and under what circumstances Proctor and Bukhenik touched, manipulated, handled, or otherwise tampered with that clothing. The MSP Evidence Submission Handbook dictates that chain of custody begins at the time of collection, and that the collector seal evidence packages as soon as possible after collection to ensure integrity of evidence items and limit loss of transient evidence. Here, in violation of MSP's stated policies, the chain of command for all of John O'Keefe's clothing, as well as dozens of pieces of taillight material, does not begin until March 14th, 2022, nearly 2 months after it was collected, when Proctor finally submitted it to the MSP crime lab. At some point before providing these clothes to the crime lab, Proctor and or Bukhenik placed pieces of the SUV taillight on them, where they were then identified by the crime lab in 2023. Proctor also planted pieces of gas on the bumper of Miss Reed's SUV while it was in his possession at the CPD Sallyport garage, which he then claimed to have recovered later on February 1st. Proctor planted this evidence to make it look like these shards originated from a cocktail glass that Mr. O'Keefe was holding when he exited the Waterfall bar. Evidently, Proctor did not plan on Karen Reed's defense attorneys insisting on forensic testing on the glass shards, which showed that they did not match the cocktail glass in Mr. O'Keefe's possession. In fact, the 5 glass pieces originated from multiple different sources. One shard of glass on the bumper did match another piece of glass that had been in Proctor's possession during the investigation. The only way for the glass to have ended up on the SUV bumper is that Proctor planted it there in an attempt to connect the vehicle to the death of Mr. O'Keefe. Oh boy. And she said, KR formally putting the MSP and the town of Canton on deck as defendants. They're not named yet only because state law requires a presentment. First, basically, a polite notice we're suing. Oh, okay. So that's why only... So you're saying that there will be others probably added to this civil suit, but they had already told these people like a month ago when they had their first hearing in that trial. By the way, we plan on suing all these people, just so you know. Okay, great. The court docs have the words "to be shattered" regarding the taillight. Interesting. All right. So other aspects of the conflicted and corrupt investigation. Proctor's, Bukhenik's, and MSP's investigation was rife with other examples of corruption and bias. For example, despite evidence that Brian Albert may have had video surveillance at the house, neither Proctor nor Bukhenik nor any member of the MSP issued subpoenas to Ring or any other home surveillance company, and no one questioned any other member of the Albert family about the presence of video monitoring. Proctor and the MSP also failed to track down other important witnesses and evidence. For example, Brian Loughran, a town of Canton snowplow operator, turned out to be one of the most significant witnesses in the entire criminal trial, also known as Lucky. Proctor and his colleagues never spoke to him during their investigation and only did so once Loughran was interviewed by a separate law enforcement agency and provided statements inconsistent with the MSP's narrative 18 months after Miss Reed was already indicted and waiting for trial. That's right. Lucky shout out. Our man Lucky. Love him. I hope he's doing okay. Specifically, Mr. Loughran drove his snowplow by the house multiple times in the early morning hours of January 29th, including at 2:30 a.m. and 3:30 a.m. He reported that there was nobody on the lawn of 34 Fairview, nor cars on the street in front of the house at 2:30 a.m. Mr. Loughran believes he would have seen a body had it been on the lawn where Mr. O'Keefe was found several hours later, and I agree. Instead, the second time he drove by the house around 3:30 a.m., Mr. Loughran saw a Ford Edge in front of the Alberts home that had not been there an hour before, but which was then parked where Mr. O'Keefe's body was later found. Brian Albert drove a Ford Edge at the time. Coincidence. However, the Ford Edge was gone by the time Ms. Reed arrived to the house around 6 a.m., and in its place, she discovered Mr. O'Keefe's body. Proctor, Bukhenik, and Tully never made any effort during the actual investigation to track down Mr. Loughran or any information relating to the Ford Edge. Proctor also secretly made efforts to protect other Albert family members during the investigation who may also have had a role in Mr. O'Keefe's death. Oh, here you go, Ange. Witness Julie Nagel told Proctor that Colin Albert, Brian Albert's nephew, had been present at the house the night of January 28th and 29th. But Proctor omitted his name from his official summary of Ms. Nagel's interview, even though he listed all others who had been present at the house with Colin. When Ms. Reed's attorneys filed a motion to obtain Proctor's notes, his handwritten memorialization of the Julie Nagel interview mirrored almost exactly what was typed up in his police report, except for the words Colin Albert. Proctor's interactions with Kevin Albert, Brian Albert's brother, during the investigation also demonstrate his close relationship with the Albert family, as well as his propensity for violating MSP rules and Massachusetts criminal laws. Repeatedly, Proctor used his personal cell phone to speak with Kevin, a CPD officer, instead of official channels when he coordinated interviews of witnesses, even though CPD was recused from the investigation. Lion Proctor, indeed. Further, in the middle of Proctor's investigation in the summer of 2022, it was discovered that Proctor and Kevin Albert were out drinking alcohol and driving in Proctor's cruiser on Cape Cod. They're so great. At the end of the night, Kevin Albert forgot to bring home his gun and badge, as one does, and left them in Proctor's cruiser. Their drinking and driving in Proctor's MSP vehicle violated both MSP policies as well as various Massachusetts criminal statutes, and further highlights the conflicted nature of MSP's investigation. Okay, I just need to point this out because I am not sure, but they keep spelling Massachusetts. I feel like they're missing an E at the end. Am I wrong? Do you drop the E when you put an S? Are any of my Massachusetts people watching that can let me know why it keeps... Is there not an E at the end? Maybe there's not. I don't know. Just like, maybe it's one of those words that I've seen spelled so many times that I'm like, is that how you spell it? Do you guys have any of the words like that? You're like, well, that doesn't seem right. And then it is. So it's correct. Oh, okay. There's no E at the end. Okay. So it's me. It's a me problem. Okay. All right. Thank you for clearing that up for me. All right. No E. Look at that. Some Llama learns about today. All right. Moreover, listen, I can never spell Massachusetts on the first try. I'll be honest with y'all. So I forget how many S's and T's there are every time. It's like Cincinnati. Okay. Just so much. So. Okay. I feel like I know, Lady in Gray. You don't know. Just kidding. Yes. Well, now I know. All right. Moreover, because of their close relationship, Proctor, Bukhenik, and Tully worked together with CPD in hiding certain videos from Karen Reed's criminal defense team. Specifically, upon information and belief, MPD and CPD collaborated to keep exculpatory surveillance video from Karen Reed's criminal defense team in preparation for the first trial. Those videos captured Brian Higgins' activities in the CPD parking lot and inside the police station shortly after the physical altercation at the house that led to Mr. O'Keefe's death. They demonstrated that Higgins' statements about his post-house party activities on the night of Mr. O'Keefe's death were not accurate. Upon information and belief, CPD knew it and knew it had this evidence and worked with MSP to keep it from Ms. Reed. Additionally, upon information and belief, CPD set its auto delete function for saving certain surveillance videos from the Sally port to 30 days, therefore assuring the immediate destruction of likely additional exculpatory evidence. The 30-day auto-delete setting conflicts with the fact that CPD videos were shared with the defense over the course of 3 years. Therefore, either the setting was changed to prevent a defense expert from auditing the footage, which is when the 30-day setting was discovered, or the footage was obtained within 30 days of January 29th and withheld from the defense. Either way, it's not great. Either way, not great. Right? I mean, it's crazy, right? How many times you've seen the word Massachusetts and you're just like, only paid attention now. All right. The indictments, trials, and aftermath. Miss Reed was arrested on February 1st, 2022, pursuant to a criminal complaint charging her with manslaughter, among other charges. She was required to post $50,000 for bail, and the court imposed several other conditions of release, including loss of her driver's license and stay-away orders from the O'Keefe family and John O'Keefe III's home. Ms. Reed was later rearrested on June 9th, 2022, after being indicted for second-degree murder, manslaughter, and leaving the scene of an accident resulting in death. Her bail was set at $100,000 by the Norfolk County Superior Court. In February of 2023, her bail was reduced to $80,000 at the defense's request. Ms. Reed was tried twice by the Commonwealth. The first trial started The first trial started in April 2024 and ended on July 1st, after the court ordered a mistrial because of a hung jury. On June 18th, 2025, following another nearly 2-month trial, Ms. Reed was acquitted of all charges associated with the death of John O'Keefe, murder, manslaughter, and leaving the scene of an accident resulting in death. For the first time in 3.5 years, Karen Reed was able to leave court knowing that the forces aligned against her had failed to convince a jury to buy their deception. Beginning in January 2022, the defendant's actions have had profound effect on Ms. Reed. She lost her employment and income. She lost her professorship. She lost her private health insurance. She lost her car and her driver's license. She lost her house. Her reputation, both personally and professionally, was utterly destroyed and will always be, since so many people think that she's still guilty. She incurred multiple millions of dollars in debt for legal fees and additional millions in expert fees and cost. In addition, after being arrested twice, jailed twice, and tried twice, she has suffered years of intense stress and emotional harm, worried that she could be imprisoned for the rest of her natural life for a crime she did not commit. Ms. Reed suffers from both Crohn's disease and multiple sclerosis. As documented under seal with the criminal court, Ms. Reed has undergone tens of surgeries to manage her illness prior to January 29th, 2022, and endured a blood infusion just months before Mr. O'Keefe's death. In the aftermath of the charges to arrest and during both trials, Ms. Reed suffered a well-documented exacerbation of her symptoms amid the stress, anxiety, and emotional and physical impacts of being wrongfully accused of murder. While fighting for her freedom against a corrupt prosecution, Ms. Reed underwent dozens upon dozens of documented medical procedures and treatments to attempt to address her health issues. The defendants concocted a plan, executed the plan, and framed an innocent woman, and they are now responsible for these extraordinary damages Ms. Reed has suffered at their hands. Oh my gosh, yes. I've heard about them, but I haven't read them. People don't understand. They can't do anything. It's fine. There's no other murder charges left that I can think of. She was already charged with most of them. And that's also not how it works. But okay. MSP investigates and punishes Proctor, Bukhenik, and Tully for their misconduct during the investigation. Proctor wrote more than 1/3 of the police reports in this case, testified at the state grand jury 3 separate times, interviewed every member of the Albert and McCabe families, had possession at least until March 14th, 2022, of all of John O'Keefe's clothing and all of the taillight pieces found broken from the housing, processed Mr. O'Keefe's Chevrolet Traverse the day after Ms. Reed was arraigned, had access to and reviewed all the ring cameras, had access to and reviewed the surveillance from C.F. McCarthy's, had possession of all of the CPD Sally Port and driveway videos, and numerous other critical investigative activities. And yet, once evidence of Proctor's conflicts and lies became public, he was extricated from this case in an effort to hide him from the jury and sanitize the compromised investigation while Miss Reed was forced to trial not once, but twice. Ultimately, Michael Proctor was relieved from duty and transferred out of the detective unit of the Norfolk County District Attorney's Office on July 7, 2024, mere days after the conclusion of Ms. Reed's first trial. Proctor was terminated from the MSP on March 19th, 2025. Upon release from the district attorney of more implicating text messages from Proctor's phone on October 18th, 2025, just last month, Proctor officially ended his appeal with the Civil Service Commission. On September 23rd, 2024, an MSP internal affairs investigation found Yuri Bukhenik failed to perform his supervisory duties in an ongoing investigation. On July 7th, 2025, Bukhenik was transferred out of the NDAO detective unit and reassigned to an administrative role in another division. Is anyone else still pissed about this? I am. I'm still pissed about this whole thing, that this is all that's happened to them. Because if it was any one of us, On October 18th, 2024, Brian Tully was disciplined and reassigned from SPDU and stripped of his detective designation. Tully was given special dispensation by Norfolk County District Attorney Michael Morrissey to continue detective work on the Reed case despite his demotion because of his behavior on this case, because that makes sense. Upon information and belief, MSP troopers David D. Seco and Jeffrey Kotokowski, these names are hard, were also disciplined for their misconduct associated with MSP's investigation of Ms. Reed. So these are the counts. Count 1, malicious prosecution under the Fourth Amendment against Proctor, Bukhenik, and Tully. The preceding paragraphs are incorporated herein by reference. Proctor, Bukhenik, and Tully violated Miss Reed's Fourth Amendment rights by engaging in a malicious prosecution of Miss Reed by causing her to be seized pursuant to legal process unsupported by probable cause. The criminal proceedings against Ms. Reed terminated in her favor when she was acquitted of murder, manslaughter, and leaving the scene of an accident with death. There's a little footnote here. After making presentment pursuant to, this is, I think, what Angie was talking about. DeChico. Thank you, Buffy. I was like, whatever. Ms. Reed will add counts against A, MSP for negligent training, supervision, and retention of MSP troopers, including Proctor, Bukhenik, and Tully, and B, the town of Canton for negligent oversight of the investigation into Mr. O'Keefe's death and of its own officers and facilities. So yeah, the saying, by the way, you guys are going to be included in this too. Because right now it's just them individually. So, all right. Proctor, Bukhenik, and Tully caused Miss Reed to be seized without probable cause as described above, including but not limited to by A, leading, handling, and participating in the O'Keefe investigation, even though Proctor was conflicted due to personal relationships with various witnesses, suspects, and potential suspects, which conflict led to Miss Reed's unlawful treatment. Handling the investigation, even though Proctor had an extreme and personal negative bias towards Karen Reed, which bias led to Ms. Reed's unlawful treatment. C, violating MSP's rules, policies, and procedures in all aspects of the investigation. D, planting, fabricating, and manipulating evidence, falsifying documents, preparing false affidavits, and committing perjury. E, failing to secure evidence in the crime scene, obtain evidence, timely and appropriately interview suspects, and investigate the Alberts, McCabes, or Higgins, and allowing them to destroy potentially exculpatory evidence. F, failing to consider and present exculpatory evidence to prosecutors and the grand jury investigating Mr. O'Keefe's death, such as the evident dog bite injuries on Mr. O'Keefe's arm and evidence that his injuries were caused by an altercation and not a vehicle strike, such as the lack of lower body trauma. Following her indictment by a grand jury, Miss Reed was rearrested without probable cause, forced to pay a $100,000 bond to be released from custody, and required to comply with numerous pretrial release provisions. These post-arraignment deprivations of her liberty constitute seizures under the Fourth Amendment. Oh, hi, Michael. Hi. Karen filed this against these people. So hi, Michael. Hope you're doing well. Those deprivations continued during Ms. Reed's second trial, in part because of Proctor's false testimony at Ms. Reed's first trial. I don't know what that noise was. It must have been my dogs. It's weird. Among other things, Proctor falsely testified that A. What is that noise? Hold on. Oh, it's Kita back there. I'm like, what is... Oh, it's Kita. She's fine. Everything's fine. All right. I scare so easily, you guys. All right, so where we were. Proctor falsely testified that A, when he first saw the taillight on Ms. Reed's car at Ms. Reed's parents' house in Dighton, it had large pieces missing, and the shattered taillight displayed at the first trial, as photographed on February 1st, 2022, was in the same condition as on January 29th. B, he and Bukhenik never touched any part of Ms. Reed's vehicle when it was stored in the CPD Sallyport. C, he retrieved tail pieces on subsequent search at the Alberts home when he knew he had deposited or arranged for someone to deposit taillight pieces at the property. Excuse me. D, Chris and Julie Albert were his loose acquaintances rather than friends. And E, his statements and sworn affidavits all claiming that Lexus was seized at 5:30 p.m. and that he arrived in Dighton at 4:30 p.m. were typos. All the typos and the butt dials and all of that. Thus, Proctor, Bukhenik, and Tully, acting under color of law, violated Ms. Reed's Fourth Amendment rights against unreasonable searches and seizures. As a proximate result of this misconduct, Ms. Reed was wrongfully prosecuted for Mr. O'Keefe's death and made to defend herself in 2 trials in the Superior Court of Norfolk County, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional and physical distress and injury. In addition to an award of damages for these harms, Ms. Reed is entitled to her attorney's fees under law, costs, interest, and punitive damages. Oh, that's right. I mean, like you're going to have to pay for Jackson. You're going to have to pay for all of them. Love that for them. All right. Supervisor, count 2, supervisor liability. This is against Bukhenik and Tully in their individual capacities. So the preceding paragraphs are incorporated herein by reference. A supervisor is liable under law when the supervisor supervises, trains, or hires a subordinate with deliberate indifference towards the possibility that the subordinate's deficient performance will result in deprivation of an individual's constitutional rights. Bukhenik and Tully knew, or should have known, that there was a grave risk that Proctor would fail to investigate the Alberts, with whom he had a close personal relationship, which he had disclosed. They also knew, or should have known, that there was a grave risk Proctor would wrongly seek to have Miss Reed charged, given the manifest bias evidenced in his text messages, which were sent to Bukhenik, among others. Yes. Bukhenik and Tully could have taken easily avoidable steps to avoid a constitutionally deficient malicious prosecution of Miss Reed. Those measures include, but are not limited to, 1, replacing Proctor with an unbiased investigator that had no personal relationship with anyone involved in Mr. O'Keefe's death. 2, safeguarding the crime scene and the physical evidence, including Mr. O'Keefe's clothing and 47 pieces of taillight material to prevent anyone from planting, manufacturing, or manipulating evidence. 3, initiating timely searches at the Alberts house. And 4, quickly seizing the cell phones and other forms of electronic evidence in the possession of the Alberts, the McCabes, and Higgins, which would have prevented their later manipulation and destruction. By not taking any of these measures, Bukhenik and Tully permitted Proctor and Tully permitted Bukhenik to violate Miss Reed's Fourth Amendment rights against unreasonable searches and seizures, and thus themselves violated Miss Reed's Fourth Amendment rights. In these ways and others, Bukhenik's conduct constituted condemnation of or acquiescence to Proctor's behavior or gross negligence amounting to deliberate indifference. In these ways and others, Tully's conduct constitute condemnation of or acquiescence to Bukhenik and Proctor's behavior or gross negligence amounting to deliberate indifference. As a proximate result of their breaches, Miss Reed was wrongfully prosecuted for Mr. O'Keefe's death, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional and physical distress and injury. In addition to an award of damages for these harms, Miss Reed is entitled to her attorney's fees, cost, interest, and punitive damages. Count 3, conspiracy to deprive Miss Reed of her Fourth Amendment rights. This count will be against Proctor, Bukhenik, Tully, the Alberts, the McCabes, and Higgins. So they're all in on this count. The preceding paragraphs are incorporated herein by reference. Proctor, Bukhenik, Tully, the Alberts, the McCabes, and Higgins shared a common design and acted in concert to frame Miss Reed for Mr. O'Keefe's death. As part of their concerted efforts and among their many other misrepresentations, the Alberts, McCabes, and Higgins agreed with each other to tell investigators that Mr. O'Keefe never entered the house, that they did not see Mr. O'Keefe in the house that night, and that Miss Reed made inculpatory statements on the morning of January 29th. When they made these statements, the House defendants did so only because they were aware that Proctor, Bukhenik, and Tully would act similarly by solely investigating Ms. Reed. Proctor, Bukhenik, and Tully knew, or should have known, that the statements made to them by the House defendants were false, and that obvious and easily obtainable evidence existed demonstrating Mr. O'Keefe went into the house where he was involved in a physical altercation during which he was beaten up, fell back, gashing his head, and attacked by a dog. Instead, because of their close personal and professional ties to the House defendants, Proctor, Bukhenik, and Tully agreed with each other to use the House defendants' misrepresentations as the predicate for and implicit direction to conduct an investigation that solely targeted Miss Reed to the exclusion of everyone and anyone else. In furtherance of this plan, among other unlawful conduct, Proctor, Bukhenik, and Tully agreed, A, to continue to handle the investigation, even though they had personal relationships with suspects in the murder, which led to unlawful and favorable treatment of potential suspects, to continue to handle the investigation, even though they had biases against investigating the House defendants because of the House defendants' ties to law enforcement. C, to continue to handle the investigation, even though they had exhibited an extreme and personal negative bias towards Karen Reed. D, to violate rules, policy, procedures in all aspects of the investigation. E, to plant, manufacture, and manipulate evidence, falsify documents, and commit perjury. F, to not secure evidence in the crime scene. G, to not investigate and obtain available evidence or timely and appropriately interview suspects. And H, to not investigate the Alberts, McCabes, or Higgins. The McCabes and Alberts coordinated their efforts through text messages, phone calls, and conversations. Higgins and Brian Albert coordinated their efforts through telephone calls and text on their phone, which were later destroyed or discarded. Finally, Proctor, Bukhenik, and Tully coordinated with the Alberts and McCabes through Proctor's sister, Courtney, who communicated frequently with Julie Albert. Acting pursuant to the plan, Proctor and Bukhenik interviewed the McCabes and Brian Albert in a cursory manner, and all at the same location, midday on January 29th and Nicole Albert on February 3rd. Proctor and Bukhenik only interviewed Higgins once at his attorney's home and did not secure or search his phone or search for communications between him, the Alberts, and the McCabes. Proctor and Bukhenik did not search the Alberts' phones or home where there was likely evidence of Mr. O'Keefe's murder. Brian Albert and Higgins destroyed or discarded their phones, destroying evidence of the murder and cover-up. As a result of the conspiracy between and among them, Proctor, Bukhenik, and Tully never investigated the House defendants, and instead, Miss Reed was wrongfully arrested and prosecuted in violation of her Fourth Amendment rights. Proctor, Bukhenik, and Tully and the House defendants acted in unison and had a peculiar power of coercion over Miss Reed because Proctor, Bukhenik, and Tully were the state police employees investigating Mr. O'Keefe's murder, and the House defendants were able to direct that investigation solely towards Miss Reed because of their personal and professional connections to Proctor, Bukhenik, and Tully, and their superior knowledge of police and criminal investigations as a result of their own work in and connection to law enforcement. The proximate result of Miss Reed's wrongful prosecution was her loss of employment, reputational damages, millions of dollars of legal expenses, and serious emotional and physical distress and injury. In addition to an award of damages for these harms, Miss Reed is entitled to her attorney fees, cost, interest, and punitive damages. Count 4. How many counts are there? I saw 7. Oh, okay. And remember, guys, with civil trials, the jury only has to like believe her and her side of the story of what happened. 51%. Okay, 51% in order to find her victorious and award her money. So like the bar is real low, and I think the McCabes and Alberts are a little delulu of how this is going to go, but we'll see. They have stuff to say, which we'll share at the end of this stream here. All right, so count 4, Massachusetts Civil Rights Act, MCRA, against Proctor, Bukhenik, Tully, Alberts, McCabes, and Higgins. The preceding paragraphs are incorporated herein by reference. By the way, I would have no desire to be on this jury. Oh boy, what a mess they have. I'd say they're fucked. Oh yeah. Oh yeah. Yikes. Yikes for them. Yikes. Proctor, Bukhenik, Tully, and the House defendants interfered or attempted to interfere with Miss Reed's exercise or enjoyment of her rights under the federal and Commonwealth Constitution and laws through threats, intimidation, or coercion. Among other acts, by manufacturing and planning evidence, not securing the crime scene, not searching the Alberts home or the Alberts and Higgins phones, and ignoring exculpatory evidence such as dog bite injuries and lack of injuries consistent with a vehicle strike, Proctor and Bukhenik caused Miss Reed's wrongful indictment, arrest, and prosecution, and thereby interfered and attempted to interfere with her rights under the Fourth Amendment to the United States Constitution and Article 14 of the Massachusetts Declaration of Rights. By falsely representing that Mr. O'Keefe never entered the Albert house and by relocating his body to the location of the Alberts property where they would claim Miss Reed dropped off Mr. O'Keefe, the Alberts, the McCabes, and Higgins caused Miss Reed's wrongful indictment, arrest, and prosecution. Brian Albert and Brian Higgins also caused Miss Reed's wrongful indictment, arrest, and prosecution by destroying or discarding their phones, eliminating exculpatory evidence. The House defendants thereby interfered and attempted to interfere with Miss Reed's rights under the Fourth Amendment to the United States Constitution and Article 14 of the Massachusetts Declaration of Rights. Miss Reed's wrongful indictment, arrest, and prosecution were intrinsically coercive under Massachusetts law. Moreover, the House defendants and Proctor's, Bukhenik's, and Tully's conduct amounted to threats, intimidation, and coercion designed to force Ms. Reed to give up her defense and plead guilty to a crime she did not commit. As a proximate result of defendants' actions, Ms. Reed was wrongfully prosecuted for Mr. O'Keefe's death, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional distress injury. In addition to an award of damages for these harms, Ms. Reed is entitled to her cost, interest, and attorney fees. Lady in Gray says, I think the suits against the cops will be a no-brainer. Oh, for sure. For sure. I mean, that's... Yes. The McCabes, Alberts, and Higgins, I think, is going to be the more questionable, decision. But as far as Proctor, Bukhenik, and Tully, like, yeah, it's not great for them. Now, count 5, common law malicious prosecution against Proctor, Bukhenik, Tully, the Alberts, the McCabes, and Higgins. The preceding paragraphs are incorporated herein by reference. By manufacturing and planting evidence, not securing the crime scene, not searching the Alberts' home or the Alberts and Higgins' phone, and ignoring exculpatory evidence such as Mr. O'Keefe's dog bite injuries and lack of injuries consistent with a vehicle strike, Proctor, Bukhenik, and Tully caused Miss Reed's indictment, arrest, and prosecution. Miss Reed's indictment, arrest, and prosecution occurred without probable cause because they were based on false, manufactured, manipulated, and planted evidence, and because Proctor, Bukhenik, and Tully ignored exculpatory evidence and allowed potentially exculpatory evidence to be destroyed. These criminal proceedings were instituted with malice, as evidenced by Proctor's, Bukhenik's, and Tully's knowledge that it was based on false evidence. Proctor's, Bukhenik's, and Tully's bias and ill will towards Miss Reed, and for the improper purpose to protect Proctor's friends and acquaintances, the Alberts. The criminal proceeding terminated in Miss Reed's favor when she was acquitted of murder, manslaughter, and leaving the scene of an accident with a death. By falsely representing that Mr. O'Keefe never entered the Albert house, and by relocating his body to the location on the Albert property where Jennifer McCabe would claim Miss Reed dropped off Mr. O'Keefe, Brian, and Nicole Albert, the McCabes, and Higgins, caused Miss Reed's wrongful indictment, arrest, and prosecution. Brian Albert and Brian Higgins also caused Miss Reed's wrongful indictment, arrest, and prosecution by destroying or discarding their phones, eliminating exculpatory evidence. As a proximate result of defendants' actions, Ms. Reed was wrongfully prosecuted for Mr. O'Keefe's death, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional distress and injury. I do think that what's been going on with the civil case against Karen, is that over with? Is that right? No. It's just starting, babes. It's just starting. The O'Keefes have sued Karen. Okay. So you have the O'Keefes who are plaintiffs, and they've sued Karen for wrongful death. Now Karen is suing Proctor, Bukhenik, Tully, Alberts, McCabes, and Higgins, plus soon the MSP, the state and city probably, where Karen's the plaintiff and they're all the defendants. And then I believe, we'll read the article as soon as I'm done with this, that the Alberts, McCabes, and Higgins are planning to countersue Karen. So listen, like, this is not going anywhere. It hasn't even gone that far. Okay. They've had one hearing regarding literally all of this. As a matter of fact, we do have a trial, or I don't know what you want to call it, trial case schedule or whatever, but we'll get to that in a minute. It's going to be some time, though, before this ever gets to trial. I can tell you that. Count 6, intentional infliction of emotional distress against Proctor, Bukhenik, Tully, Alberts, McCabes, and Higgins. The preceding paragraphs are incorporated herein by reference. By manufacturing and planting evidence, not securing the crime scene, not searching the Alberts' home or the Alberts and Higgins' phones, and ignoring exculpatory evidence, such as Mr. O'Keefe's dog bites and lack of injuries consistent with a vehicle strike, Proctor, Bukhenik, and Tully caused Miss Reed's indictment, arrest, and prosecution. By falsely representing that Mr. O'Keefe never entered the Albert house, and by relocating his body to the location on the Albert property where Jennifer McCabe claimed Miss Reed dropped at Mr. O'Keefe, the Alberts, McCabes, and Higgins caused Ms. Reed's wrongful indictment, arrest, and prosecution of Ms. Reed. Brian Albert and Brian Higgins also caused Ms. Reed's wrongful indictment, arrest, and prosecution by destroying or discarding their phones, eliminating exculpatory evidence. The defendants knew or should have known their conduct would cause Ms. Reed emotional distress, since it would lead to her prosecution for murder and other crimes. And the conduct did cause and is causing Ms. Reed severe emotional and physical distress. The defendant's conduct perverted the justice system, allowing Mr. O'Keefe's true killer to escape liability and threaten to imprison Miss Reed. It is the type of behavior that threatens civilized society and is therefore extreme and outrageous. Agreed. As a proximate result of defendant's actions, Miss Reed suffered serious emotional and physical distress and injury. All right, civil conspiracy against Proctor, Bukhenik, Tully, McAlberts, McCabes, and Higgins. The preceding paragraphs are incorporated herein by reference. Proctor, Bukhenik, Tully, the Alberts, the McCabes, and Higgins shared a common design and acted in concert to frame Miss Reed for Mr. O'Keefe's death. As part of their concentrated efforts and among their many other misrepresentations, the Alberts, McCabes, and Higgins agreed with each other to tell investigators that Mr. O'Keefe never entered the house, that they did not see Mr. O'Keefe in the house that night, and that Ms. Reed made inculpatory statements on the morning of January 29th. When they made these statements, the House defendants did so only because they were aware that Proctor, Bukhenik, and Tully would also act similarly by solely investigating Ms. Reed. Proctor, Bukhenik, and Tully knew or should have known that statements made to them by the House defendants were false and that obvious and easily obtainable evidence existed demonstrating Mr. O'Keefe went into the house where he was involved in a physical altercation during which he was beaten up, fell back gashing his head, and attacked by a dog. Instead, because of their close personal and professional ties to the House defendants, Proctor, Bukhenik, and Tully agreed with each other to use the House defendants' misrepresentations as the predicate for an implicit direction to conduct an investigation that solely targeted Ms. Reed to the exclusion of everyone and anyone else. In furtherance of the conspiracy, Proctor, Tully, Bukhenik agreed to fabricate, plant, and manipulate evidence purporting to show that Ms. Reed's vehicle hit Mr. O'Keefe. Pursuant to their plan, Proctor, Bukhenik, and Tully carried out multiple overt acts, including damaging the taillight on Miss Reed's vehicle while it was in the town of Canton Sallyport, not securing the crime scene, and depositing taillight pieces on January 29th prior to the MSP CERT team's arrival on site. In addition, Proctor deposited some of the broken taillight pieces on Mr. O'Keefe's clothing while the clothing was in his protected custody. Proctor also deposited glass alleged to have been from a cocktail glass on the bumper of Miss Reed's Lexus SUV sometime prior to the vehicle's processing by MSPCL on February 1st, 2022. Another part of the conspiracy was to take coordinated steps to ignore and destroy potentially exculpatory evidence that pointed to other suspects like the Alberts and Higgins. The McCabes, the Alberts, and Higgins coordinated through text messages, phone calls, and on information and belief conversations. Higgins and Brian Albert coordinated through telephone calls and on information belief text on their phones, which was later destroyed or discarded. Finally, Proctor coordinated with the Alberts and McCabes through his sister, Courtney, who spoke frequently with Julie Albert. Acting pursuant to the plan, Proctor and Bukhenik interviewed the McCabes and Brian Albert in a cursory manner the morning of January 29th, and Nicole Albert on February 3rd. All told the same false story that Mr. O'Keefe never entered the Alberts' house. Proctor, Bukhenik, and Tully also only interviewed Higgins once with his attorney at his attorney's home and did not secure or search Higgins' phone or search for communications between him and the Alberts and the McCabes. Pursuant to the coordinated plan, Proctor, Bukhenik, and Tully also did not search the Alberts' phones or home where there was likely evidence of O'Keefe's murder. Further, Brian Albert Higgins destroyed or discarded their phones, destroying evidence of the murder and cover-up. Following Mr. O'Keefe's death, among other acts, the McCabes and Alberts agreed to make it look like Mr. O'Keefe died due to exposure after being hit by Karen Reed's car. As part of this common plan, Brian Albert and Higgins, both law enforcement officers familiar with investigations, communicated at 2:22 a.m. on January 29th after Higgins left the house. Shortly thereafter, as part of the plan, Jennifer McCabe deleted a Google search at 2:27 a.m. on January 9th for how long it takes a person to die in the cold, or how's long to die in cold. One or more of them then relocated Mr. O'Keefe's body and deposited it in front of the Alberts house, where Jennifer McCabe claimed Miss Reed had dropped Mr. O'Keefe off earlier. The McCabes and Alberts then coordinated what they would say to the police, all of them falsely telling investigators that Mr. O'Keefe never entered the house. Proctor, Bukhenik, Tully, and the House defendants acted in unison and had a peculiar power of coercion over Miss Reed, because Proctor, Bukhenik, and Tully were the state and police employees investigating Mr. O'Keefe's murder, and the House defendants were able to direct the investigation solely towards Miss Reed because of their personal and professional connections to Proctor, Bukhenik, and Tully, and their superior knowledge of police and criminal investigations as a result of their own work in and connection to law enforcement. Proctor's, Buchenek's, Tully's, and the House defendants' conduct described herein were unlawful and tortuous, not torturous. Among other things, they constitute intentional infliction of emotional distress, negligence, common law malicious prosecution, and violations of Ms. Reed's rights pursuant to the United States Constitution and the Massachusetts Declaration of Rights. As a proximate result of defendants' actions, Ms. Reed was wrongfully prosecuted for Mr. O'Keefe's death, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional and physical distress and injury. Ms. Reed respectfully requests a jury trial on all matters so triable, wherefore Ms. Reed respectfully requests that the court grant her the following relief. A. Enter judgment in her favor and against each relevant defendant on each count of this complaint. B. Award her damages in an amount to be calculated at trial, along with pre- and post-judgment interest, costs, and expenses. Award her reasonable attorney fees incurred in connection with this litigation pursuant to the law and any other applicable statute or law. And D. Grant her such other relief as the court deems equitable and just. Oh boy. Well, that was a lot. That was also, there wasn't really anything new in there. It was just like a brief of, putting everything that we learned together there. What is, I don't know what that's for. That must be for something else. So don't worry, we're not done quite yet because there is more. Sorry, hold on. Agreed. Hello, Martin. Hello. All right. So I saw this last night before I was going to bed. So this is an article where the witnesses plan defamation lawsuit against Karen Reed and Turtle Boy blogger Aidan Kearney. What? I don't know if he's done he probably has done a reaction about this already. It was pretty late when I saw this. But oh man, can't wait to hear what Turtle Boy has to say about this. So 5 witnesses in the Karen Reed case said they plan to sue her and Turtle Boy blogger Aidan Kearney for defamation in the wake of Reed's 2 high-profile criminal trials and amid an ongoing civil case. The potential plaintiffs include Jen and Matt McCabe, Brian and Nicole Albert, and Brian Higgins. During her criminal trial, Reed accused them of being the real killers of John O'Keefe and attempting to frame her. Kearney was a vocal advocate for Reed's claims, and prosecutors alleged that the two communicated about the case, sometimes through third parties. Kearney still faces witness intimidation cases stemming from those events. Oh, I thought those went away. Did they not? Oh. In a new legal brief, the witnesses argue that Reed created a vile work of fiction concocted to evade responsibilities for her actions. The defamation case against Reed and Kearney has not yet been filed, and the brief gives no indication when that might happen. You guys, they're such dum-tums if they do they. Okay. In response, Reed's lawyer said, quote, "Truth is an absolute defense to a claim of defamation. We will defend Karen Reed vigorously against such baseless claims." Reed was found not guilty of murder this summer after her second high-profile trial in the death of Boston police officer John O'Keefe, her boyfriend, but guilty of a lesser charge of drunken driving. O'Keefe was found dead during a snowstorm on January 29, 2022. Throughout her two criminal trials, Reed's defense team claimed that someone else was responsible for killing O'Keefe and that Reed was the victim of a law enforcement cover-up. After the verdict, an attorney for the Albert and McCabes families called the decision a devastating miscarriage of justice. Well, I very much disagree with them. Reed's legal team announced in September their plan to pursue civil allegations against investigators and witnesses involved in her criminal trials, which we just read, because they have filed it. The McAlberts and Higgins have not filed anything yet. They alleged civil rights violations, civil conspiracy, and negligence against the Massachusetts State Police, Sergeant Yuri Bukhenik, Detective Lieutenant Brian Tully, and disgraced former trooper Michael Proctor. Reed's team wants to accuse the Canton Police Department of negligence and to further accuse the Alberts, the McCabes, and ATF agent Brian Higgins of civil conspiracy and civil rights violations. Jennifer McCabe, a key witness, delivered a lengthy testimony over 3 days in April and May in Reed's retrial because she wanted to read everything all over again every single time. McCabe testified that she was at the Waterfall Bar and Grill with the couple on the night in question and asked them to go to the Alberts family house on Fairview Road after the bar closed. She and her husband, Matt McCabe, both said they saw Reed's SUV outside 34 Fairview Road because they were looking out the window all the time. Totally normal. Don't think about it too hard. But that neither O'Keefe nor Reed ever came inside. The defense alleged that McCabe's phone was used to search Google for how long to die in cold. It's house long. Get it right. At 2:27 a.m., hours before O'Keefe's body was found in the snow. The prosecution disputed the time of the search and says Reed asked her to do the search after the body was found. McCabe previously testified that she drove a hysterical Reed to Fairview Road in Reed's SUV, where she said Reed spotted O'Keefe in the snow before anyone else and repeatedly made incriminating statements. The O'Keefe's family existing lawsuit against Reed and the bars is scheduled to return to court on Friday, this Friday. I do not know if it's going to be streamed yet. We have eyes on it. I told everyone to keep their eyes and let me know if they are going to stream that hearing, but I don't think there's going to be much to it, but we never know. Okay, so those are those two things. Now I've got, hold on, let me adjust some things because, oh, that's right. So this is, so they do this very interesting thing there where they have like a timeline of when certain stuff is due by for a civil trial, which I find very interesting. Hold on. Does that make help? No, it doesn't help. All right. That's as big as it's going to get. So this is for Karen Reed versus Michael Proctor. Okay. So this is for Karen's civil lawsuit where she's the plaintiff, not the O'Keefe's and versus Karen Reed. Though since they're very close in time, it's probably all going to be very close in time now. So as you can see, they have a list of when certain things need to be served by. filed by, and heard by. And if you see right at the bottom, I don't know if you guys can see, the states of litigation. All right. So the service of process made and returned filed with the court, it needs to be filed by February 17th of next year. All right. This is going to be a long time, you guys. Response to the complaint by March of next year. All motions under MRCP was already served by March 18th of next year, filed by April 17th of next year, heard by May 18th of next year. All motions under MRCP 15 served by January 12th, 2027, filed by February 11th, 2027, heard by February 11th, 2027. All discovery requests in depositions served and non-expert depositions completed by November 8th, 2027. So, final pretrial conference held and or firm trial day set by May 8th, 2028. Case shall be resolved and judgment shall issue by November 17th, 2028. And that's just for what we just read today. So it's going to be a while. It's going to be a while for this. And I imagine the timeline's probably very similar to the O'Keefe's first read one. So yes, this is the one for the one she just filed. So just remember that. This is going to be the case that keeps on giving. I know, right? Is it going to be Judge Bev? I don't think so. Actually, even with the last hearing that we had in September, I think that judge is off and a new one is on it now. So I don't even know who the judge is. I think it's a whole different one. So you got nothing but time. Now, there is some other stuff that I can't really share because I don't feel like downloading it all, but it comes from X and from Angie. So we have, let me scroll up. Maybe if I was in the right Discord chat. There we go. What do we got here? Okay. So Ted Daniels posted on Twitter a statement from our favorite attorney, Alan Jackson, and the Karen Reed civil team. All right. So, and she believes that Ted Daniels works for a local news, Boston 25, probably. It says, I've reached out to the lawyers for the McCabes, Alberts, O'Keefes, and Brian Higgins about Karen Reed's new lawsuit and their proposed claim against her. I'll let you know if I hear back. This just released statement is from Alan Jackson and Karen Reed's civil team, though. So this is what he has to say about that. Quote, today's filing speaks for itself. It is a meticulously documented civil action grounded in evidence, law, and the Constitution. For more than 3 years, Karen Reed was dragged through a baseless criminal prosecution engineered by individuals who abused their authority, manipulated the investigative process, and trampled her rights. Our complaint lays out in stark detail the malicious prosecution, the conspiracy, the civil rights violations, and the intentional misconduct that those defendants visited upon an innocent woman. If these defendants want to answer for that under oath, we welcome it. I'd love to. What we will not do is legitimize a threat to file some imaginary defamation case. That threat is nothing more than a desperate attempt by these defendants to distract the public from the very real legal jeopardy they now face. When people start waving around defamation claims to mask their own legal troubles, it tells you everything you need to know. They don't want sunlight, they want silence. Karen Reed spent years fighting for her freedom against a corrupted investigation. Now she is fighting for accountability. And unlike the criminal case, this time the defendants don't get to hide behind badges, back-channel favors, or manufactured narratives. They will have to answer in a court of law for every lie, every omission, every manipulated report, and every constitutional violation they committed. Karen Reed is not backing down. Our team is not backing down. Accountability is coming, and these defendants can threaten all the phantom lawsuits they want, but the truth doesn't flinch. Oh, savage. Love that. Love that for us. There's also a new statement from the attorneys for Brian Higgins, Nicole Albert, Brian Albert, Jennifer McCabe, and Matthew McCabe. Oh boy. Let's see what this is. Quote, the allegations made by Karen Reed are entirely false, defamatory, and without merit. Our clients categorically deny each and every claim. This lawsuit is nothing more than a continuation of a baseless conspiracy narrative that has caused significant harm to the reputations and lives of innocent people. Our clients acted responsibly, fulfilling their civic duty as witnesses, and have participated appropriately in the legal process from the outset. Ms. Reed's claims distort the facts, misrepresent the evidence, and target private citizens in an attempt to deflect blame. Okay, as reported yesterday, we will hold Ms. Reed accountable for the harm she has inflicted and the conspiracy she and Aiden Kearney, also known as Turtle Boy, have manufactured. Okay. Oh boy, get out of here. Jeez Louise. What? That last response that I just read was from the attorneys of Brian Higgins, Nicole Albert, Brian Albert, Jennifer McCabe, and Matthew McCabe. So I am not sure. That's a good question. I don't know. I've never really seen or read about a civil case with like this many different players and all the different laws. I have no idea. I have no idea how this is supposed to go. It sounds like it's going to be an absolute mess. I know that at the civil hearing in September, her lawyers were requesting that all of the lawsuits that everybody wants to file, that all of them should just all be merged into one trial. Instead of doing separate ones, separate for O'Keefe's and Karen, separate for Karen versus all these people, and any count, they should all just be done at the same time, to which I agree, because even then I don't know if I agree, because it's kind of a little convoluted. But that last statement, sir, get out of here, or ma'am, I don't know, it didn't specify the attorney's name, but what? We all watched it. So yes, this is the case that what we just read that Karen Reed filed yesterday. So it's okay. It is confusing, right? No. So the O'Keefes have sued Karen Reed for wrongful death. That we watched in September. That one's already underway. In that hearing, I don't remember the attorney's name, but I think he was like South African or Australian. I don't know. I really liked his accent. But he asked the judge, he told him, we plan on filing a lawsuit against all these freaking people. We're going to do it. And would it be possible if we just went ahead and included it in this wrongful death trial? Because it's all going to be the same people, the same experts. Why waste so much time for all these separate trials that's all about the same thing? And the judge was like, I don't know. He didn't really give an answer. So we already knew that Karen's lawsuit against the McCabes, Alberts, and Higgins was coming. They did say so. Now, Higgins, the Alberts, McCabes have not filed a defamation lawsuit against Karen yet. They're just saying, well, we're going to do it. We're going to do it. Like, oh, okay. You do it, buddy. I can't wait for you to have to provide evidence for things, but you probably disposed of it in a dumpster in a military base or something, that normal people just do. So It's a mess. How can they sue for wrongful death if she was found innocent? That's a really good question. I suggest you take a look at the O.J. Simpson trial. Is a really a good example. It's because the bar is lower, is my understanding, right? So O.J. Simpson, for example, was found not guilty. All right, and Goldman and gosh, I can't remember his wife's name right now. Their families filed a wrongful death lawsuit against OJ and won, where OJ was found to be the killer. So, and cause a wrongful death of them. So it does happen. But remember, the bars are very different between criminal and civil. Okay. So, because you don't need to prove as much. Like reasonable doubt just really isn't a thing in the civil trials as it is here. So that's just, I mean, he was still found not guilty. All right. Not guilty does not mean innocent. I know. But that's a very Nicole Brown, thank you. Oh gosh. I've read a lot. I've been reading since 10 o'clock or 11 o'clock this morning, you guys. So a lot going on. So who knows how that's going to happen, but I love it. I'm so excited. I'm excited to see what comes out of that. And I don't blame Karen one bit. I think that it's easily going to be found for Proctor and Bukhenik and Tully, the procedures that they were supposed to follow. I think those are going to be easy to get guilties on and have them pay. The others, well, I don't know, but maybe. You never know how that's going to go. But it does look like a trial's not going to be for a couple of years. But anytime they do have something like really good come out, I'm not going to read every single thing that's dropped in this civil case. If it's just boring papers, formal stuff, we won't go into it. But I will try to cover it as much as possible while we are waiting for the trial, because we don't want to get too behind in this clusterfuck case. We missed a couple filings and then we don't know anything because it's all over the place with so many different people. So we will definitely be doing that. Let's see, do I have anything to tell you guys? Oh, well, Friday is supposed to be a hearing for the O'Keefe versus Karen Reed civil trial. Don't know if it's going to be streamed or not. If it is, then we will cover that. If it's not going to be, I'll probably maybe just do like read Chad Daybell's letters at the end of the day or something like that. So, yeah. So that's all I got for you guys today. I saw that this morning, even though we didn't learn anything new. It was good. It was a good refresher. It's a good refresher. I'm glad that they did it. I'm so glad that they did it. Oh man. And the other thing with civil suits, right, is the depositions. All right. So every witness basically is deposed ahead of time. All right. Where they sit in a room, lawyers from both sides are there. It's taped, it's transcribed, the whole thing. Everybody's going to be deposed. Okay. And then they go to court and then they're on the stand, right? And they also have, the lawyers have what happened during this deposition and they have video of it. So, and they could go on for hours. Okay. So we'll see. We will see. Between that and Walsh, what a day. What a day indeed. I was just supposed to, be done with Llama Learns About, work on some, stuff for the channel, and nope, we went down that road. What a wild road it was. Well, you guys, that is all I have for you today. I do have to quickly go because I do have a phone call I need to make because they've been waiting and I should probably do that. But yes, we'll stay updated with any of this tomorrow. I think there's Midday Missing tomorrow. I'm not sure. So it could be a book. Oh my gosh. It could be several books, I think. Oh man, right? They might want to use their old transcripts so they can remember what they said in the first place, right? Mm, mm. I love this for them. I love this for them. All right, you guys. Well, I do have to go. I hope you have a wonderful rest of this Tuesday, and we'll see each other more over this week, of course. But I do have to go for now. So until next time, thank you all very much, and go forth and be amazing. Bye, guys.